This discussion now. The police's Operation Receipt campaign to recover alleged looted goods in communities has certainly come under fire from certain sectors of society. This is after officers broke into some shacks and raided homes, leading to questions around the legality of these actions. In some instances, food items, appliances and building materials were seized from homes while the owners were actually at work. There were also cases where goods were seized despite the owners themselves being able to produce receipts showing that they had actually bought them. We want to know this morning, do the affected people have any kind of recourse? To help us answer that question, let's bring in the Socio-Economic Rights Institute's Executive Director Nomzamo Zondo, who joins us now via our video link. Nomzamo, great to see you. Thanks for making time. I mean, in a statement that you released on this matter, you say there are several issues, several problems specifically with the raids that took place. Take us through, perhaps as a start, what you found to be specifically problematic.
Sure, thanks so much, Ayanda. So firstly, we are a country that actually looks down on warrantless searches. This is because of our history. In fact, the Constitutional Court more than twice has spoken about how the reason why the apartheid police would search homes without a warrant is because they felt that poor people, black people, didn't have any dignity to be respected and no privacy protected. So already, you're already breaching two very fundamental rights. If you remember, we are a country that's based on the right to dignity by having a warrantless searches. But the problems are compounded in this circumstance, because not only did the police search without a warrant, if there was a warrant, there would have been safeguards on what the police must do. For instance, in how they must communicate with the owners of the homes, what they must provide as acknowledgement of what they've seized. We know that in what we saw, it was a sort of free for all being managed by the police through these warrantless raids.
Yeah.
And sorry.
No, please go ahead.
Sure. And that brings a real problem of how do people challenge these raids. If the police didn't give you a receipt, if they didn't acknowledge what they took from you, are you in a position to then go? Where do you even go? Right? They didn't get a name of who the police officer is. They didn't know of which police station they could go to challenge the seizure of their goods. They weren't given any case number, which means that in effect, in the most simplest way, without engaging a court, they are not in a position to challenge these seizures, because they don't even know where to start. Where do they go to say, actually, someone took my 12.5 of flour. I bought it from shop, but I don't have the receipt. I do have the receipt, but this is mine. It was not taken through the looting, and that's the first problem that we have. The second problem, when this started, Ayanda, it started as an issue of the rule of law, and for us, that means the state was saying citizens are acting outside of the rule of law. That means for us, at the very least, the state itself must act within the rule of law. And for us, that means when you are in your home, one, you expect that you are safe from any intrusion, right? That's what the right of privacy guarantees you. You are safe from any intrusion, including intrusion from the state. And if there is going to be intrusion from the state, let there be safeguards that protect you, that protect your children. I mean, for me, every time I kept seeing these warrantless raids, I was wondering about kids who've been left at home alone, who just see the police kicking doors in, the trauma that will remain with them after this. And with all of that having happened in countless communities, without any direction even being given by senior police officers on the ground to say, actually, this is how we are going to act, this is how we're going to make sure this operation, and then they were able to justify it, has happened. And what I'm struggling with mostly is, when all is said and done, the only thing that these communities can do is go to the court, which means that they must have resources to engage legal representatives who must go to the courts, who must challenge under the promotion.
Let me come in there, Nomzamo, because that's exactly the kind of complexity I was hoping to ventilate. I mean, we can't ignore the community specifically here that was targeted. It's Sebokeng, which we know it is at the intersection of various socio-economic problems in our country, unemployment, poverty, and inequality. Many people describing this in some respects as some kind of war against the poor. Another disappointment.
Exactly. In our press release, we see this as a criminalization of the poor. And also this understanding that rights are for those who have resources. It is, in fact, discrimination of people based on their class. The police have acted in a way that completely disregards these communities' rights. So you mentioned that happened in Sebokeng, but it first started in Alex. right? It started in informal settlement in Alex. Again, you see exactly what type of community was targeted. And also the way the police acted. And also because we know here that there is simply no way that the police can trace these goods back to any shop. So this is the situation where the police are saying we are acting in order to, we are reclaiming these goods. We're going to send them back to their rightful owners. Even worse, what we know almost certainly has happened here, that people who had goods in their homes have had those goods taken away from them, and they have no legal recourse. That's been put by the state. I think the minister has acted irresponsibly here.
Yeah.
Because when he declared Operation Show Us the Receipts, he should have put, at the very least from his office, without even an understanding of the law, he should have put safeguards of how he expects the police to act.
Yeah, on that note, I mean, of course, many communities now will want, at the very least, a level of accountability. You've mentioned the police minister as among the people who've dropped the ball, but what is to be said about the people who are carrying out the raids on the ground? Surely they too must have, at the most, a basic level or basic grasp of what the law requires of them. And they too, it appears, had completely neglected that.
Look, so it is in the Criminal Procedure Act, Ayanda, the police can carry out warrantless searches, but the circumstances are so constrained, right? It says to you, you can only carry out a warrantless search if, one, you believe that if you had applied for a warrant, you would have received one, but waiting or delaying to apply for that warrant would make you lose the evidence. What we know, for instance, is what happened in Sebokeng happened a week after this incident. So the police had a week to actually go and apply for the warrants in the different magistrates districts that they were in. They could have applied for it in any of the high courts, either in Johannesburg or in KwaZulu-Natal. They had the time to do this. And the one thing that I would say is available to communities right now is they have a right to complain to IPID against the police officers who are on the ground. Both the station commanders and the police who were in charge of those operations should have a list of each and every police official who was on the ground. In fact, they have occurrence books where they have to record what they did. And I think that is the first source of information that the communities can rely on. They can go back to say, okay, this is what happened in my community. I must go at the very least first to my police station. I can go to the provincial office of the SAT to say, this happened in my community, and this is how it was carried out. This is how our rights were affected. And we demand that you disclose to us both the list of the police officers who were there, 2 copies of their occurrence book, and then, because we intend to lodge complaints with IPID. But even beyond that, I'd like to invite IPID to say, IPID must investigate this, must investigate the action of the police here, because they are aware that in this case, multiple rights were breached during a police operation.
So the recourse is that the communities can go to court, but what does the redress actually look like? I mean, what, if anything, can community members come out of this with, considering how far-reaching, the infringements of their rights actually was here?
So, there's one very complex legal question that we're still waiting for the Constitutional Court to determine, and one of them, it relates to whether the state must pay constitutional damages, must compensate communities whose rights have been breached in this circumstance. So, in fact, SERI brought a case on behalf of close to 3,000 residents of the inner city of Joburg who had their homes raided during Mashaba's reign, under what was known as Mashaba's raids. And we've asked the Constitutional Court to say, actually, these are the kind of circumstances where you should, as the court, condemn the action of the state and actually show the state that there will be consequences for your action, which would then increase the likelihood of the state acting differently in the future. So that's one possibility. But secondly, we have had the Supreme Court of Appeal in a case of Ngomane actually provide damages to a community who had been evicted unlawfully by the police, saying that at the very least, because the community could show that actually this is what we lost, because, or at least this we would need this amount of money to replace what was taken from us by the police. But those are those are 2 distinct situations. Like one, you have someone who says, I lost goods that I had bought because of this raid, and I can't claim them back. And the Ngomane situation would cater for that. The other one is the trauma that has been experienced in those communities. Yeah. It's a violation of rights that has happened in multiple communities. And the question is how do we then have closure of that? And we argued before the Constitutional Court last year that the court must actually, and the courts generally, and the law must allow for such violations of rights, for there to be some sort of compensation for communities.
Very quickly then, Nomzamo, since we're speaking about legal conundrums, I mean, it's also incredibly important for the state to be seen to be sending out a message that looting and criminality does not yield any kind of benefit. So I can imagine many within that side of this argument contending that the state also couldn't do nothing in response to the looting that took place. If that is to be accepted, what kind of action would have been appropriate?
It's very simple, and I've spoken to it. They could have gone to the courts and gotten a warrant, which have ensured that they had searches that were guarded, searches that were safeguarded, where they looked for these goods, and then also in that process they would have maintained a level of respect, a level of dignity in these communities. So no one is saying the police must do nothing, but everybody is saying the police must act within the law. You cannot come as the police to say there was lawlessness, and because there was lawlessness, I will also act with lawlessness. They cannot act with impunity. They must, as the state, lead by example, and make sure that in their actions they've acted appropriately. So here we're not saying the police must do nothing. They must go and get warrants, and they must go and search in communities. If they have evidence and complaints, then they must open criminal cases, but they cannot act as they have.
Sure. A lot to think about there. Nomzamo Zondo, thanks very much indeed for your time. Really appreciate your insights on this issue. Nomzamo is the Executive Director at the Socio-Economic Rights Institute. Once again, thanks very much indeed.